Hello folks, welcome to Lexi IAS Academy. In this video, we will be discussing your Polity GS paper 2 topics from your center-state relations, where we will be discussing recent issues, Supreme Court verdicts, understanding so as to help you in your mains preparation. Let's get started. In today's video, we will be covering your Delhi services dispute. We will also be discussing on your Domestic Violence Act and the need for uniform implementation, especially in your union territories. We will be discussing on your Waqf Amendment Act of 2025. We will be discussing the need for permanent consumer courts and more specifically the highlight on what is the present scenario and what more can be done ahead. We will be discussing about the constitutional provisions for environment, and we will also be at the end seeing how do you balance center-state relations and also improving the governance in your union territories. Alright, this video is presented to you by your faculty Sushma KP. Let's get the video started. Now, first and foremost, when we say Delhi's services dispute, as usual, I'll tell it to you like a story, you listen to it like a story. The issue between your elected government of Delhi and Lieutenant Governor has been a very long standing one, wherein many people have even dubbed it as the balance or the power between the selected and elected. What does it mean? See, first and foremost, with Delhi, many people are claiming that it has to be given a statehood, but then there is also an equal amount of claim that no, this is the face of India, this is the face of the capital, so the power has to be retained with the center. So much so that the criticisms that your NCT, National Capital Territory, has drawn is it really a special status or just a glorified municipal body? You can use these kind of statements. So now what is NCT? Your National Capital Territory of Delhi is nothing but one particular body that is having the feature of a legislative assembly and also a lieutenant governor. So this is where they are telling, is it a special union territory or a just glorified municipal body? Why they are telling it, we will discuss. So as of now, what is the issue? See, with respect to your NCT, State Legislative Assembly will have control of the administrative machinery of the state except land, police, public order. That is under the center. The center claims because this is the face of the country and this is of a very high critical nature, because everything what happens here reflects the center. So based on that, it says that land, police and public order must be in the hands of center. Rest all is in the form of your state legislative assembly or elected state government. The issue now comes in is with regarding to the services or your bureaucracy. Who should maintain control of your bureaucracy? Is it the elected government or the center? Understanding? And if you see the constitutional provisions of Delhi, special status was given to your Delhi based on your Balakrishna committee recommendations, according to which Article 239AA. One other thing about your Article 239A is the reason there is a constitutional ambiguity is because it doesn't make a special reference to the services or your bureaucracy. This is the reason why there is fight. The center claims that because it is of very important nature, the services, that is the bureaucracy, must lie with the center. The state government is claiming that no, because the administration of the state is with respect to the people's power, people's trust in the government, then the services also should be under your state government. Understanding? So your Government of National Capital Territory of Delhi Act of 1991 establishes an overall framework as to how the functioning is. Now the issue is with respect to the services or your bureaucracy. Another thing with respect to your, you can have other states or union territories. If you see, if it is a only union territory, complete control is under the center. State, they have to follow according to the seventh schedule, state list, central list, concurrent list. But there are certain union territories, like for example Delhi, Puducherry, which also have a legislative assembly and a lieutenant governor. Under this, they are technically not falling between the state, they are not technically falling between your union territory. Okay, now the issue is coming with respect to your services, right? So, what does this mean? The difficulty of having a lieutenant governor and a Delhi government means that there is dual power. When there is dual power, this leads to decision making delay, where most of the time the lieutenant governor refers the matters to the president, bypassing the CM and council of ministers. It also leads to democratic eruption and also policy paralysis. It takes and lags a long amount of time to implement anything which is by the need of the hour. For this, what did Supreme Court decide? See, the issue on as to who gets to be, that is, who gets the services, bureaucracy under them, has been the fight since legally from 2015 onwards, wherein 2015 pe initially it was a two bench judge. They said that no, this requires, both of them gave differing opinions. They said no, a three-judge bench should decide. When it went for three-judge bench, it said that no, a higher bench is also needed and more we have to look into this. So finally in 2018, a five-judge bench sat, wherein they said that the lieutenant governor is bound by the aid and advice of CM and COM in all matters except public order, police, and land. Okay. Then again in 2023, what happened was it held the same thing where it held that see your services or your bureaucracy is a part of executive. If it is a part of executive, then it has to fall under the ambit of Delhi government and not the center. To the center goes just this public order, land and police. The rest of the bureaucracies, that is with respect to transfers or posting of bureaucrats in the Delhi, is all under the ambit of your Delhi government. This was brought about. And in the meanwhile, a lot of things happened in Delhi also, wherein the power, that is the state government which is in power, changed, and the recent government removed, or that is took back all the cases, wherein they are now trying to build in a good relationship with the center. That's a different thing. Now, just this phase is where we are concerned about, the 2023 phase, when the judiciary held that no, the services are under the ambit of, or it comes under executive, and that is part of your state administrative machinery, which means it goes to Delhi government. Now, what happened? Your center, immediately president issues an ordinance. He issues an ordinance, and on the aftermath, based on that, a bill is also introduced, which is passed by both the houses. One of the main things before we delve into the specifics is this particular ordinance or bill was in a way diluting the Supreme Court's judgment. Otherwise, it was again exercising the center's control over Delhi. Now we will look into the specifics as to what was the ordinance passed, what was the bill passed, what is the key specific features. The ordinance that was passed immediately after your judiciary's judgment, which said that the services are under the ambit of state government, that is your Delhi government. Government of National Capital Territory of Delhi Amendment Ordinance 2023, President passed, wherein the Lieutenant Governor will decide with regarding to the services and if he consults the chief minister, it is only based on discretion. Then after this, they introduced a bill that was a Government of National Capital Territory of Delhi Amendment Bill 2023, which was passed by both houses, according to which they will establish something called as National Capital Civil Service Authority, which is a body and which will have three members. First thing is Chief Minister of Delhi, who will act as a chairperson, Principal Home Secretary, and Chief Secretary. Now, both of these, Principal Home Secretary and Chief Secretary, will be appointed by the center. Whatever decision this particular body takes, that is there. Now, this decision will also be taken based on majority of votes. See, these two are appointed by a center, and another one person from your elected government is only the chief minister. And they are also telling, yes, the majority of the votes pay, the decision lies. So in a way, it is center trying to withhold, that is, hold back its position over Delhi. And also it says, in case there is a difference of opinion between this authority and lieutenant governor, then the final ultimate decision will be that of your lieutenant governor. Understanding? So this comes amidst your Supreme Court's judgment of services under the ambit of your Delhi government. So if you see what are the recommendations that are made to deal with your Delhi governance, first thing is to codify the powers of Lieutenant Governor under Article 239A. Another thing is empower Delhi Assembly in administrative matters. Promote cooperative federalism is because, see, unless and until the whole basic structure, whenever we keep telling federalism is a basic structure, that is to make sure that it does not create further paralysis. See, many judgments and also previous commissions have also held that the power of lieutenant governor should not be that of an obstructionist. Understanding? So, this should not become a zone for power play. And another thing is to train the officers in federal ethics, which means to avoid bureaucratic resistance. So as to make sure, because they are the part of the permanent executive, meaning they are the ones who are the first step of contact with your civilians. So what can be done with regarding to your Delhi governance? A separate Delhi Coordination Commission can be set up, which is based on your Sarkaria style of center state dealing with the issues, and also create a legal clarity as to who exactly has the power, and also create binding judgments. And at the same point of time, bring in the other things like we said, codify your lieutenant governance powers. Understanding? What is a possible mains questions that we can expect from this topic? Discuss the constitutional and administrative issues. Like we mentioned, how the article is silent with regard to services and administrative issues, like we mentioned, your dual powers, your role of lieutenant governor should not be acting as an obstructionist. Okay, these you have to be discussing. Involved in the NCT of Delhi's demand for greater autonomy. Next, in the context of recent Supreme Court verdicts, examine the balance between center supremacies and union territories' democratic matters. Understanding? Basically, we'll speak about union territories without legislative assemblies, union territories with legislative assemblies. The next topic is Domestic Violence Act should be implemented uniformly throughout the country, especially in your union territories, Supreme Court has held. Look at this. Protection of women from domestic violence under your Domestic Violence Act 2005. This we will be discussing. Look at this. First, we'll see what are the constitutional provisions with respect to your women's protection. First thing is Article 14, right to equality. Then is Article 15 of 3, state can make special provisions for women. This does not come under discrimination but rather under your betterment. Article 21 is the right to life and personal liberty. And also, the same themes are highlighted in the directive principles of state policy under Article 39 of T and 42, which speaks about your equal pay, humane conditions, etc. Now, when we say domestic violence, first and foremost, understand one thing. Domestic violence means you try to prevent the sort of abuses put upon a woman in different forms, be it physical abuse, emotional abuse, economical abuse, sexual abuse. So, a lot of abuse from the family members. Here, it could even mean the husband, the in laws, the sister in laws, so any of them. The thing that happens with respect to your domestic violence is you have to consider it in a broader picture. For example, why this issue has come up. The judiciary held that in many states and especially in your union territories, there are no protection officers. So much so that in certain union territories, there is only one protection officer for the entire area or for the entire union territory. And also, even if they exist, the protection officers in many states, they are having dual responsibilities. So they are overburdened. Second thing is understaffed. Third thing is delay in funds, and also funds are not allocated on this. Alongside this, see when we say domestic abuse, which means a person is coming out, we said protection officers should be there. Second thing your Domestic Violence Act speaks about is first provision of a shelter homes. In most cases, shelter homes are not present because of your lack of funds, and in other cases, the shelter homes are clubbed with juvenile homes. So because of this, what is happening? There is a issue in the infrastructure. Third thing is there is lack of awareness. Fourth and the largest thing is even to report these cases, go to these houses, there is a lot of social stigma associated with this. Understanding? So, what are the issues in appointment that is in implementation of Domestic Violence Act? Non-appointment of protection officers. This applies for both your states and union territories as well. Especially in union territories, the condition is much more worse. Second is lack of shelters or legal aid which has to be given for the women. Poor implementation. Yes, the laws are there, but the implementation is not on par. The ground reality is not how it is. Another thing is gender justice gap. So, your Supreme Court has given direction stating that the domestic violence have to be implemented uniformly throughout the country, including states and union territories. Which means what? All states must immediately comply with the Act's provisions of first and foremost, you set up a protection officer, create a DV house, that is a shelter homes, and then make sure that a proper awareness is raised about these things. And third thing is create a set of deadlines that you have to meet within this point of time. You have to report on time. So basically, you create the aftermath. You just do not tell how you create this and leave it. You create deadlines. If not compliance, if they have not complied, give them some sort of punishments. That is, you have to meet the deadlines. Understanding? So this would mean that it will be done in a faster manner. So what are the recommendations for your implementing of Domestic Violence Act? First thing is you dedicate and allocate specific budget for your domestic violence in your union territories. See, with respect to union territories without state legislative assembly, they are under complete control of your central government. Because of which there is no local or your legislative pushback also possible, so which means center has to take a proactive step. Women commissioners should be appointed in union territories and also create a more of awareness on this. And third thing is make digital tracking through dashboards so people can also be availing this information. And also how much of the project is getting implemented also should be provided through real-time updates. So this would mean for a faster implementation and also your accountability can be taken into fact. What can be done with regarding to your Domestic Violence Act? First and foremost, local empowerment. You take the help of your local government, that is your Panchayat Raj municipalities, NGOs, to assist the union territories. Next is to invoke your judicial monitoring, where High Court has to be given the permission, where the updates or how much of the deadline have they completed, how much of compliance have they been undergoing should be given to your High Courts. And based on your Justice Verma committee recommendations, first thing is to strengthen institutional mechanism. And according to your National Commission for Women report, you allocate dedicated funds and also create women commissioners. Yeah. What are the possible mains questions that we can see from this topic? Supreme Court plays a pivotal role in enforcing social legislation discussed in the context of Domestic Violence Act. See, first and foremost, look at this term, social legislation, a law for the society. There are certain things when you do, it is not considered as a crime against a woman but crime against humanity. We've seen a lot of dowry cases, bride burnings, and all of these things which are not tolerated. Understanding? Look at this. Evaluate the challenges in implementing women centric laws in union territories. First, here you will speak about the jurisdiction. If it's a union territory without a legislative assembly, then again it is 100% controlled by a center. That is again having, again, there is no limits or checkbacks for your autonomy that the center has. And also, one more main thing is that there should be mechanisms which has to hold the center, just hold these bodies accountable. Understanding? So there is where you will bring for both the question, Justice Verma committee recommendation, National Commission for Women committee recommendations. Okay, National Commission for Women. The next topic we will be seeing is Waqf Amendment Act. Yeah, have a look at this. What is the issue here? First and foremost, look at this. Center claims no Waqf board can claim government land. Your Waqf board or your Waqf amendment ignited a lot of public outcry, and the decision from your judiciary is also still pending. For this, first thing we have to see is what is the constitutional provision of Waqf. According to Article 25 and 26 of Fundamental Rights, it is with regarding to freedom of religious and religious institutions. Article 300A, which deals with right to property. Seventh schedule, that is in your seventh schedule of lists, which are central list, state list, and your concurrent list. Land comes under state list. Okay. But if it is a union territory, then it is under your center's jurisdiction. First and foremost, let's understand a simple meaning of Waqf. Let's say I have property, either a movable asset or immovable asset. I donate it. Okay, I'm a Muslim and I donate this land. Now this goes under Waqf property. Now the issue that has happened is, just based on my extended use of this particular place, I cannot call it as a Waqf property, which means I should have proper documentations that this property is mine. This particular topic is widely contested because of the claim that the impact of this might affect a lot of dargahs, cemeteries, prayer halls. Why? Because these were all not having any proper documentation. Yes or no? Now coming back. What are the issues in this Waqf Act? Religious rights versus state ownership. See, first and foremost, your religious institutions, etc., are claiming that, see, if you are going to make a rule, then let it be the same for all the religious institutions and endorsements. Why only this you're targeting? The state or your center holds the view that no one institution can claim government's land. Another is the issue of unclear documentation, which begins with the underground prime essence of Waqf properties. The center is claiming you need proper documentation, whereas they are telling then this one move, if it is agreed, then this will impact all of this dargahs, mosques, cemeteries, all of those they did not have any of the proper documentation, and it is all by the use only. Another thing is politicization of this issue is one of the main reasons why it has become so much widely debated. Another thing is your union territories where states pay, yes, it is a state list. But with respect to union territories, everything comes under your center. This word, Waqf by user, just because of my extended usage of a particular piece of land, that does not make me entitled to tell, yes, now I'm writing it or I'm donating this. Now it will become a Waqf land, which means once, let's say I have a land, I've been using it. And now what I do? I will donate it. Now, once if it goes to your Waqf property, then they have all the rights with regarding to maintenance of that, acquisition of that, understanding? So they get the rights. As of now, there is a stay put on this, that is, the judiciary is yet to give its decision on Waqf by user land claims, which means just by your extension usage, you cannot claim that land as yours. There should be a proper documentation, verification, records stating that the land is yours. So, what are the key changes that was done in your Waqf Amendment Act? Abolition of Waqf by user. This is one of the main key contention areas. Just me usage of that for an extended period will not bring it under the ambit of your Waqf land. Look at this, solely on the use of over the time. Mandatory evidence, which means you have to give written, documentary and legal proof which is required for registration. The center tells that center will now be empowered to review the Waqf board decisions, which they are claiming affects the autonomy and also it affects their fundamental rights. And with respect to UTs, that is Union Territories, center can directly denotify Waqf property because again, why? States pay, it is the land is under state list, but Union Territory 100% under your center, right? And the appeal process, they have told that it cannot go to the civil courts, which means the powers are curtailed and it can only go to your higher courts or Waqf tribunal. Now, what are the recommendations that can be done with regarding to your Waqf board? See, first and foremost, you create a national Waqf land registry, so as to identify which places are coming under this. Second thing is you digitize this, understanding, which means you have to make sure that they are geotagged, and also you make sure that yes, these are all coming under the proper classification. And third thing is create a national land commission, a neutral land commission for states and union territories. One of the main thing is treat all the religious endowments trust bodies equally. So, how can you manage with the Waqf land issues? Sovereign land control, which means religious rights do not override sovereign land control. And another thing is maintain a balance between secular governance and religious sentiments. Otherwise, our key cornerstone, maintain a sense of secularism, which involves with respect to all the religious institutions and endowments. So, what is a possible mains question that we can expect from this? How should India balance between religious freedom with public interest in land management? Discuss with reference to the Waqf Act. So, here you will mention about the key challenges and changes that has been made to your Waqf Act of 2025. The next topic that we will be seeing is permanent consumer courts. See, with respect to permanent consumer courts, one thing we all know with regarding to our judiciary is highly strained, stressed, overworked, understaffed, etc. One thing your judiciary has highlighted, that is your consumer courts are suffering very badly, A, because of lack of infrastructure, B, lack of staff, and also if you see the jurisdiction, let's say if someone is getting affected in the Lakshadweep, they have to come to border, that is they have to come to Kerala. Understanding they have to travel long distances for access of basic justice. Your access to justice is your Article 21 right to life. Yes, so this is getting affected of people, especially largely in your union territories. Why is this happening? Because you do not have a specific dedicated consumer courts. You have not appointed the necessary staff in it, and also consumer court staff, etc., should be judicial in nature and not bureaucratic in nature. So judiciary has given more of your aid, advice, whatever we call it, to your center and state that create permanent consumer courts, because this is also affecting their Article 21 or right to life. Look at this. Under Article 38 of your DPSP, it is the role of state to ensure justice and welfare. According to Article 21, it comes under right to life and personal liberty, which also means fair treatment, include consumer protection. Then under your Consumer Protection Act of 2019, which speaks largely about your consumer rights. What are the issues? Again, there is no dedicated infrastructure, permanent court setup specifically for consumer protection. It is severely understaffed, and also the union territories lack permanent district consumer forums. They have to go on to other states. They have to come to, for like I said, Lakshadweep, they have to come to your Kerala. There is huge bureaucratic delay in the grievance redressal, and there is digital inefficiency. So they are telling bring in digitization, bring in e-courts, so that there will be faster and speedy resolving of cases. Understanding? With respect to the consumer courts, they have highlighted two things: infrastructure, staffs for permanent courts across your union territories. The same has been with respect to your union territories, even with legislative assemblies. For example, Ladakh suffers the highest because of this, even though it is again before your separation, and after separation also the condition of your Ladakh has remained almost the same only. They are facing it very difficult with respect to your consumer courts. What are the recommendations there for your that is what can be done with regarding to your consumer protection? First and foremost, to create e-consumer platforms for your grievance redressal from your union territories. And second thing is annual review by your consumers affairs ministry, and you recruit trained legal personnel in union territories. That means not a bureaucratic personnel, but rather your legal personnel, something judiciary affiliated. So what can be done? Treat consumer rights as an essential service, and that forms the basic rights of your access to justice. And also your union territory should be empowered through your budgeting, infrastructure, personnel, understanding grievance redressal mechanisms. These all should be brought in. What is a possible mains question that can come from this? Consumer protection is a key pillar of economic democracy. Discuss how it can be strengthened in the UTs. The same things that we discussed. The next topic is retrospective environmental clearance. See, first and foremost, to understand one thing. In a developing country, this is a common issue between your environmental protection and improving the ease of doing business. So there is a two fine line we have to speak about. See, environmental protection is a constitutional mandate for us. Ease of doing business is very much needed for a country, and also that is what will progress for an economy which is as fast growing as India. These two are on parallel terms with each other. Both have to be, see, if this is ease of doing business, this is how it is becoming environmental protection. If you have to bring in a project, then both have to meet somewhere, get the approval. You have to have your environmental protection, that is sanctions from your Ministry of Environment, and then they move in synergy. But what is happening? This is taking, let's say this is environment, this is business. This is also needed, this is also needed for the growth of our country. Both of them have to meet somewhere, synergy, and then go ahead. The issue is this is causing huge delays. This they are not able to wait that long. So what they said was, with government, they decided, see, before a project has to begin, it has to get environmental clearance. But because of its delay, the government has started with something called as the retrospective environmental clearance, which means you start the project without the environmental clearance. After you begin, then you can get the clearance and then you can continue. Supreme Court has held that this retrospective environmental clearance is almost like telling that it's okay, we are not bothered about your environmental impact, and it is violating the entire basic principle of the principle polluter pays the fine. Understanding, if you are telling no need of environmental clearance for your project to start, it is almost like you are agreeing with this behavior. You are going against the principality of polluter pays the fine. So this is against our constitutional morality, against constitutional framework, against constitutional safeguard. That is why a judiciary has struck down retrospective environmental clearance. Understanding? Look at this. So what are the constitutional provisions that we have with regarding to safeguard of our environment? Article 48A, protection and improvement of environment. Article 21, right to life, which also includes a right to clean environment. And Environmental Protection Act of 1986, which deals with the lengthy legislation with regarding to environmental protection. Now, first thing is, when you are telling start the project, later you can start the project without environmental clearance, you are trying to bypass the norms, or otherwise ex ante clearance norms. You need to start the project only with the clearance. If you are starting the project without the clearance, then you are bypassing the norms, which will impact the environment. See, one of the largest example that we can take, that India is suffering still, and if we do not take environment seriously, that is your Bhopal gas tragedy. Understanding, something, one mistake could cause and could impact many generations to come. Understanding? Now, for example, we see in your Chernobyl, right? Still today, we observe how much of an impact that particular place has had. So, just on the lines of trying to do ease of doing business or creating business or for economic, you cannot violate or bypass environment. After all, and at the end of the day, it is one world we have. EIA compliance gap in many union territories because of your administrative machineries, gaps, implementation, etc. And also, this has brought about, yes, there is delay. What can be done is, you can promote environment friendly practices. Isn't that all your SDGs about? Sustainable business models, sustainable goals, right? But these things are very actively tried to be bypassed in developing countries, where the norms are more stringent in your Western countries. So, your Supreme Court held that retrospective clearance on environment constitutes to be illegal and unconstitutional, and it reinforced the polluter pays and precautionary principles. So which means through that your retrospective environmental clearance cannot happen. What can be done? First thing is you create environmental impact assessment cells or EIA cells in your union territories. Because see, at the end of the day, when you say union territories, they are called union territories because of their special status. They have a special role, the people have a special culture, so that has to be protected and nurtured. Local stakeholders should be informed. In fact, the clearance, the environmental clearance should be made public through your dashboards. The local people must be fully aware of the things that is going to happen and must receive their nod. Yes, this might add to delays, but this will be better for the long run. And remote sensing also should be provided, digitization for clearance projects, these are also to be maintained. What is the way forward we can do? First thing is national compliance portal has to be created to make sure that yes, it is on track and on par. And also to an extent you can keep judiciary also involved. Again, here we are telling only to an extent, so as to make sure the compliance is on par. What is a possible mains question that we can expect from this topic? Retrospective environmental clearance defeats the very essence of sustainable development. The whole point you are trying to create sustainable development is so as to all the factors of the society are in congruence. When you are bypassing that through your retrospective environmental clearance, then you are defeating, you are putting the country back. What role should judiciary play in protecting environmental rights in centrally administered territories, that is your union territories? That's where we said only in your union territories judiciary has to be involved to one extent and also create a compliance portals. There are previous year questions with respect to your center state relations that we see very largely and also the union territories. 2021 mains question, look at this. Indian constitutions has provisions for a federal structure with strong unitary basis. Bias discussed in the context of recent political developments. See, we can speak this with respect to your Waqf. We can speak of all the topics that we discussed with respect to your domestic violence, with respect to environmental clearance, right? Judiciary plays an active role in upholding cooperative federalism. Illustrate with examples. Again, the same things that we discussed. Okay, your judiciary has held that federal features of the constitution is a basic structure. Okay, the Indian federal system is skewed in the favor of center. Examine the statement in the light of recent center state and center union territory relations. We can speak on provisions during your emergency, understanding the option of your president's rule, right? Your role of lieutenant governors, administrators. Yes, all of this you can discuss. So, because we're speaking with respect to your union territory, Article 239 is there for your administration of union territories. Article 239A is special provisions for your Delhi. Article 29, right to life and personal liberty. Article 15, prohibition of discrimination, which has to be all seen in congruence together. How do you balance your center state relations? First and foremost, constitutional challenges are some, administrative challenges are some. If you say administrative challenges, the dual control system, the dual source of power is affecting the state machinery. Bureaucratic resistance for change and lack of clear demarcation of powers, like for example, we see with respect to lieutenant governor appointed by the center and also your elected government from your Delhi. Constitutional challenges, again, limited powers for your union territories, centers overriding authority, judicial interpretation of federal provisions. Union territories are still having a large chunk of issues with respect to administrative inefficiency also. Your Jammu and Kashmir is asking for restoration of statehood. Understanding? So what can be done to strengthen your union territory? Legal reforms, which means amend laws to clarify proper center union territory power distribution, create permanent coordinating bodies between your center and union territories. Now, when we said Sarkaria Commission and all, we spoke about zonal councils, we spoke about your interstate councils. So, like that, create a coordinating mechanism between your center and union territories. Then you create digital governance so as to bring in transparency in the administration, and so as to people will be able to view and visualize the administration, and then have a judicial oversight for your center and union territory disputes. Understanding? So this is for your center state relations in the recent years with respect to your union territories. Understanding? Now, we've reached the end of the content. If you like our content, subscribe to our channel, hit the like button and share it along with your friends. Thank you.